All right. So my topic is adjudicating religious sincerity, and this PowerPoint follows pretty closely along with my paper. So I'm going to be starting off with a review of court cases. So the first court case I wanted to touch on was United States v. Ballard, which happened in 1944. This was a landmark court case in which the Supreme Court decided for the first time not to accept religious claims brought before them. This established that the courts would not always agree with the claimant's position on religious freedom, and it also brought up a debate that scholars currently discuss a lot, which is accuracy or truthfulness versus sincerity. And a well known philosopher actually explained the difference between the two. He said, in a simple definition, accuracy is the nature of acquiring a correct belief in the first place and then transporting that belief in a reliable form to others. In contrast, sincerity is the nature to say what one actually believes. So accuracy is just being able to basically recount a religious claim or religious belief, but sincerity is to actually believe in it. And so they decided in this court case in Ballard that the courts would not be debating the truthfulness of a religious claim, but they would be to arbitrate religious sincerity. And this became known as the Ballard Rule. The next court case was Sherbert v. Werner in 1963. This opened the door for religious groups and individuals to see a wide range of laws that conflicted with the tenets of their faiths due to laws that imposed penalties either for engaging in religiously motivated conduct or for refusing to engage in religiously prohibited conduct. And so this became known as the Sherbert test. The Sherbert test requires the courts to decide sincerity and then decide if there's an undue burden placed on the claimant's ability to practice their belief. It then requires the court to outline a compelling state interest and prove that the state has pursued this interest in the simplest, most logical way in order to not produce harm to the person or religion. Both the Ballard Rule and the Sherbert test flirt with the idea of adjudicating sincerity, but they suggest no standard on how to do so. And these two cases really set the stage for adjudicating religious sincerity in scholarly debate. The next few cases I wanted to cover just kind of give a timeline for how the Ballard Rule and the Sherbert test kind of evolved. The first one was Wisconsin v. Yoder in 1972. This was a case where an Amish couple wanted to exempt their children from finishing the last 2 years of public education so that they could homeschool them and teach them gospel things and also have them work on their farm. And the court actually ruled that this was okay, that it was not just a personal preference, but that it was a strong religious desire. The next one was Thomas v. Review Board of the Indiana Employment Security Division, which happened 9 years later. This was a case in the state of Indiana where a Jehovah's Witness man was fired from his job for refusing to make turrets for military tanks. He had strong religious beliefs that this was creating war and that war is sinful, and he went to apply for unemployment benefits and was denied. But the court found that this was a religious, sincere belief, and so they allowed him to have unemployment benefits. The next case is Fraze v. Illinois Department of Employment Security in 1989. This one took these top two cases one step further. A man said he needed to be exempted from working on Sunday due to personal religious beliefs. However, he did not belong to any particular religious denomination, but the court ruled that, quote, in order to be protected, the claimant's beliefs must be sincere, but they need not be consistent, coherent, clearly articulated, or congruent with those of the claimant's religious denomination. And so they allowed him accommodations to not work on Sunday despite him not belonging to any particular religion. The next case that I talked about in my paper was Employment Division v. Smith, which happened in 1990, and we've already talked a great deal about this case, so I won't go into a lot of detail. But this was a case in which the court held that the use of peyote in religious ceremonies was not a sincere enough belief to warrant unemployment benefits. Following this case, the U.S. government did not like the decision, and so they created both the Religious Freedom Restoration Act, or RFRA, and the Religious Land Use and Institutionalized Persons Act. RFRA is if a person's sincere belief is substantially burdened, the government must provide accommodations or show that the action pursues a compelling state interest by narrowly tailored means. And the Religious Land Use and Institutionalized Persons Act allows prisoners the right to worship as they please and defines religious exercise as, quote, including any exercise of religion, whether or not compelled by or central to a system of religious belief. Both these congressional acts play into the next two cases, which the first one is Cutter v. Wilkinson in 2005, which dealt with 5 inmates who had non-mainstream religions. They were the only ones who had these religious beliefs, but the court ruled that there needed to be accommodations for them to practice their beliefs. And the second one is Holt v. Hobbs in 2015, in which the court ruled that a Muslim prisoner was allowed to keep a 1-inch beard. And so both of these were kind of aftermaths of Employment Division v. Smith. The last court case that I wanted to touch on here was Burwell v. Hobby Lobby, which happened in 2014. This case basically sparked the debate on adjudicating religious sincerity that scholars have now, and it's also the basis for my paper, my thesis. This is mostly due to the fact that before this case, the Ballard Rule and the Sherbert test were very clear-cut and a very good standard for people to follow. But during this case, 3 Supreme Court justices actually expressed opinions that opposed the court being able to determine sincerity. The first of which was Justice Ginsburg, who stated that any allegations brought before the court must be accepted as true. This statement was very consistent with the court's belief about sincerity before the Ballard case. The second justice was Justice Kagan, who stated in his oral arguments that it would be unconstitutional to test the sincerity of religion, and Justice Sotomayor agreed, saying that it was the most dangerous piece of a religious accommodation analysis. So all of these justices, even though those opinions were expressed in the dissent, their voices were heard loud and clear amongst scholars, and a lot of people take these sides of the argument. All these court cases that I've discussed lead me to my thesis, which is stated, the Supreme Court should be the main decider on sincere beliefs and ought to have a system in place that accurately adjudicates religious sincerity based on 2 crucial prongs. First, the burden of persuasion falls upon the shoulders of the person or group claiming religious accommodations, and second, the belief must be free from pretense, deceit, or hypocrisy. The next section that I wanted to discuss was a review of academic literature, and there's still a relatively new topic, and so there's not a lot of information published on this, but the articles that I did read were very extensive and had a lot of really good ideas. The first one I wanted to highlight was Vincent Philip Munoz of the University of Notre Dame. He dives into claims of religious exemptions from military service in relation to the Second Amendment. He explains that if a belief is presented before the court and deemed sincere, then this person could potentially get out of military service if their religious beliefs might be that war is a sin and so they are not able to go to war. He concluded that, quote, the presence of free exercise protections combined with the recognition of religious exemptions from militia service in the state constitutions of the time further supports the conclusion that the right to religious free exercise was not understood to include exceptions. Going off of this, the next scholar is Michael W. McConnell from Stanford University. He also agrees with Munoz's idea, but he expresses that even modern day Supreme Court justices, such as Justice Stevens, agrees with these claims. He explains, Justice Stevens argues that exemptions directed to religion alone are generally unwarranted because determining the sincerity of religious claimants is dangerously intrusive, because granting exceptions for religious beliefs discriminates against secular beliefs, and because special treatment may give the appearance of aid to an endorsement of religion. So both of these ideas really touch on the concept of exemptions. And I just wanted to touch on that just a little bit. At the same time that a court is deciding if a belief is sincere or not, they are also deciding if the claimant will receive religious exemptions. If a person is determined to have sincere beliefs, the chance that they will receive an exemption from the law is very likely. If the beliefs are not sincere, however, exemptions will most likely not occur. So these two ideas are very intertwined, and so I use them in my paper just like the other scholars do and use them kind of interchangeably. The next group of scholars that I wanted to touch on actually have the opposite view. They believe that the court should adjudicate religious sincerity. The first one is Nathan Chapman from the University of Georgia, and he says, quote, "Insincere claims impose costs on the government, third parties, and religious liberty itself, and that the courts can adjudicate sincerity and reduce these costs." So he is worried about the dangers of having insincere claims brought before the court. The second scholar is Anne Sue of the University of Toronto. She suggests that the courts go beyond the uncritical embrace of sincerity requirement as part of the judicial decision, and that the courts need to examine costs and risks of allowing insincere beliefs to be accommodated. She believes that the courts ought to have an extensive test that helps them determine sincerity, but she doesn't really go into detail on what that test should be. Both of these scholars also suggest that exemptions to law due to sincere religious claims are necessary. And I agree with these scholars. These both fit right along with my thesis, and we all agree that the courts should adjudicate religious sincerity. This leads right into the test that I suggested. This has two axioms. The first is the burden of persuasion or the burden of proof. The burden of persuasion in this case is placed on the plaintiff claiming religious accommodations, and they are either desiring to be excluded from participating in a certain activity or be allowed to take part in an activity contrary to public norms. This axiom is necessary because I argue that it would be inappropriate for the courts to be required to present evidence as to why an individual or group does or does not deserve religious exemptions. This axiom would also deter insincere claims from being brought to the court, which was a problem that the previous scholar, Anne Sue, discussed. This would provide that only the most genuine individuals would bring their arguments to the court, knowing that they would need to prove beyond a shadow of a doubt that their beliefs are in fact sincere. This would hopefully deter insincere claims from being presented before the court. So the second axiom of my test is that the claim must be free from pretense, deceit, or hypocrisy. So anyone who decides to undergo the burden of persuasion must be consistent in their actions and words in what they are claiming to believe, which includes both public and private actions. I also think the person's beliefs must have some historical basis. There needs to be proof that the person didn't just adopt specific religious beliefs just for the sake of getting out of doing something or for being able to do something. Under this axiom, I believe the court case Phrase v. Illinois Department of Employment Security, which happened in 1989, would have been decided differently. This was the case in which a man did not belong to any particular religion, but he was exempted from working on Sunday. And so, under this standard, it would be his burden of persuasion to prove to the court that these beliefs to not work on Sunday have some historical basis, that he has been practicing them for a very long time and not just because this job now requires him to work on Sunday. Another part of this prong deals with harm, and I think this is important to mention that the courts ought to keep in mind that the purpose of religion is to better oneself. This purpose in no way condones false beliefs that infringe upon another person's rights. And so the court should keep this in mind, that any belief that they deem sincere must not harm anyone or any other religion in any big or small way. The final section I wanted to go over were some counterclaims, and the first one I have is a First Amendment interpretation. So the argument is that the First Amendment specifically outlines complete freedom of religions, which would give citizens the right to worship as they please. In this case, it would mean sincerity would not be an issue. These arguments are consistent with Munoz and McConnell's arguments as well. My rebuttal to this is that if we allowed everyone to just do as they please and claim this as a religious freedom, this could lead to a parade of horribles. Justice Scalia also makes this argument in Employment Division v. Smith, basically saying that if we allowed these two men to smoke peyote and get away with unemployment benefits, then we would need to give unemployment benefits for a variety of reasons, and then just allow people to use a ton of illegal drugs for the use of religious ceremonies. And this would be very bad. The court would become stuck with a set of rules that required them to allow American citizens to get away with basically any illegal activity as long as they chalked it up to a religious belief. The second counterclaim I wanted to address was that of favoritism. Some accuse the court of favoring some religions over another. And this is also coupled by a Pew Research Center poll, which found that 70% of the United States is Christian. And so there would be a huge advantage for the Supreme Court to side with the majority of citizens on religious issues. However, my rebuttal is filled with court cases that prove otherwise. The first one is the Church of the Lukumi Babluaye, which is a case in which the court sided with this small church, allowing them to have animal sacrifices as part of their ceremonies. The second case is Wisconsin v. Yoder, which I've discussed previously. It was the case with the Amish parents. And the third one is Cutter v. Wilkinson, which was also previously discussed. That was the one with the 5 inmates who were allowed accommodations for practicing in their prison. All these instances show the court's ability to stand by smaller religions in American law. In conclusion, the Supreme Court should be the main decider on sincere beliefs, and they ought to have a system in place that accurately adjudicates religious sincerity. My test that I have suggested includes the burden of persuasion and that the claim must be free from pretense, deceit, or hypocrisy. I believe this test to be effective and necessary so that the courts can stay consistent in deciding the sincerity of a claim. This is my presentation. I hope you enjoyed.